All right. We have both players here.
Yes, Your Honor.
Yes, Your
All
Honor.
right, let's proceed.
Thank you. May it please the court, Heather DeGrave on behalf of the appellant Hopheads, and I'd like to reserve 5 minutes for rebuttal.
You got it.
The final judgments in this case should be reversed because they were entered in disregard of two fundamental principles of civil litigation. One, that the issues that are tried at trial should be only those issues that are actually framed by the pleadings. And two, that damages are determined as of the commencement of the case. In this case, the only two ways that appellee may be entitled to judgment for the full principle of the note at issue was one, because the note has matured and the borrower has failed to pay the balance in full without valid excuse, or two, appellee had properly accelerated the note. It's clear from several statements by the trial court during closing argument at trial and in the findings of fact and conclusions of law that the court considered the fact that by the trial date, the maturity date had passed. And the judge considered that to be relevant to the entry of final judgment. However, and in addition, Mr. Callio testified that the full amount was due, not because there had been an acceleration of the note. In fact, he testified that there had not been an acceleration of the note, but because the note had matured by the trial date. But the problem is that at the time of the commencement of the case, and even at the time of the filing of the second amended complaint in the action, neither the original note nor the extended note had reached a maturity date. So it wasn't included in the pleadings, and final judgment in the case below should not have issued based on the maturity date.
But Ms. DeGrave, in the second amended complaint, I think it's in paragraph 16, it alleges that the borrower defaulted under the loan documents by failing to make the monthly payments due in December of 2014 and other payments thereafter. How does that not solve the problem that you're complaining about?
Well, two things, because at the time of the filing of the complaint, at the time of the filing of the second amended complaint, the maturity date had not yet come. So
okay, but that would, if what you're arguing is then somebody could never bring an action on the default of the note unless the maturity date had passed, as opposed to a default, which is what was brought here.
Right. No, I'm not saying that.
Okay.
I'm saying that what the case law is that when you have a note that includes installment payments, that each failure to miss is itself a breach that could give rise to a cause of action. But unless there's an acceleration of the note or you've reached the maturity date, the full balance of the note is not yet due. All that's due is the missed payments. That would be all that's due. So at the time of the commencement of the case, unless there's been an acceleration of the note, the full value of the note was not yet due, and so
even under the lights of your argument, Ms. DeGrave, because the kind of the touchstone of the lack of notice of pleading is whether or not your client is in any way prejudiced. How can they possibly claim any kind of prejudice when they're already subject to an existing lawsuit and are presumably aware of the terms of the note and were aware that it had reached maturity? I mean, it's hard for me to imagine how they can credibly claim in good faith to have been caught unaware that, oh goodness, we are indeed going to argue the issue that this note which maturity date has passed has come mature and that they're seeking the full damages under either theory, whether it's acceleration or maturity.
Right. Well, and the thing is twofold. First of all, the defendants may have had a number of defenses why the balance wasn't paid at maturity, and one of those could have been the actual pendency of this proceeding. So if you have the foreclosure proceeding pending with a Liz pendants pending, that may impair, if to the extent that the defendants wanted to use the property as leverage to obtain the funds needed to pay the balloon payment, they would have been impaired in their ability to do so by the pendency of this foreclosure proceeding for the full amount, even though the loan had not been accelerated.
What does that have to do with prejudice and in vis-a-vis the litigation itself? Because that's what your argument is, that this was a pleading deficiency. And so the prejudice has to be measured in terms of how your clients litigated and were caught unawares as a result of this purported pleading deficiency. That's what I'm trying to drill in on. That in every foreclosure case, every default case, there's always going to be ancillary matters about, well, if the bank just wouldn't foreclose, I could do this, and that. But I'm trying to keep this focused on your argument, which is a purported pleading deficiency.
Right. So if you look at the trial transcript, you can see that counsel for the defendants, Mr. Meacham, was preparing the defense of waiver and estoppel with respect to the acceleration of the note. And he's starting to question Mr. Kallio with respect to the acceleration of the note so that he can attack that. And then Mr. Kallio says, no, there was no acceleration of the note. The reason why the full amount is now due is because we've reached the maturity date. So here we are at trial for the first time learning that now the reason why they're saying that,
and that kind of goes back to what I said at the beginning. I mean, the note is attached to the pleading, right? Everybody can read the maturity date. And that's why I'm having a hard time accepting this argument, is that it's really hard for me to understand how anyone can claim to be prejudiced, that the argument is being made, hey, we're due the entire note because the maturity date has come and gone in the course of this litigation, when the note was front and center there, and they're already in litigation about default on the note.
Well, the thing is that if the plaintiff had either amended its pleading before trial, shortly before trial, or had what would have actually been more appropriate under the rules, is done a supplemental pleading, which said that this maturity date accrued while it was pending, and had the supplemental pleading, then the defendants would have had the opportunity to file and pursue their defenses, including, hey, we were going to use this property as our leverage to obtain the funds necessary to make that balloon payment, but we couldn't do that because it was subject to this lis pendens. So no, it was subject to this lis pendens for
How would that have even been a cognizable defense to the maturity date default?
Because if the lis pendens is impaired, then no lender who might otherwise.
I understand how LPs work. I'm just trying to figure out your argument that they sued us. There's an LP out there. We were going to use the property to pay off the note. Okay, great. But what does that have to do with the fact that the note's mature now and you haven't paid it?
That's what I'm getting at, that's not a
defense.
It matured while the improper foreclosure proceeding, because the foreclosure proceeding was improper.
Okay, so this all of this flows from your notion that this is the whole proceeding shouldn't have been brought.
Yeah, because because the note had not been accelerated. That's what Mr. Kallio testified to, yet they demanded the full balance. Not only did they demand the full balance, they actually demanded $379,000 in the complaint. That's what they said was due, even though it was impossible that the principal amount was $379 at the time that was had sold, because the maximum principal of the note was $300,000. So you have a lis pendens and a complaint that's saying that this property is encumbered by this $379,000 obligation.
Did you all challenge the LP at any time? Did you seek to dissolve it?
Well, it's not that we sought to it's not that the defendant sought to dissolve it. The point being that the fact that the date note matured during this proceeding, one of the defenses among others, and I'm not trial counsel, so I wasn't privy to, there may be other defenses that the defendants knew about and would have raised with respect to why we didn't pay the balloon payment on maturity. But one that I can foresee is that this foreclosure proceeding was pending, and so they couldn't obtain in an improper amount, and so they couldn't obtain the funds that they needed to make the balloon payment. But the point being is that because the idea of the maturity being a basis for the full value of the note was not pleaded. And so my clients were not able to meet that pleading with a defense. What was pleaded was that the note had been accelerated. And as you see in Mr. Meacham's questioning of Mr. Callue, he was preparing to meet that claim. He was preparing to meet that claim with it, A, it wasn't accelerated, and B, there
Did
were
Mr. Meacham
equitable
request a
reasons why.
continuance?
No, Mr. Meacham did not request a continuance, but Mr. Meacham did argue in closing that the issues are framed by the pleadings, and so that the judgment can only be based on the pleadings as asserted. So he did reserve that argument at trial. In addition, and so by basing the judgment on an issue that was not pleaded, it deprived defendants of a meaningful opportunity to respond with its defenses. In addition, as I mentioned, the evidence at trial was that the note itself had not been accelerated. So the full value wasn't, the evidence at trial was that the full value wasn't due based on an acceleration of the note. The acceleration provision in the note is optional. It's optional so which means under Florida law that it's not automatic, it's not self-executing. The plaintiff has to take an affirmative act to trigger it. And what Mr. Callue testified to is no, we have not triggered it. And this idea that without notice, it doesn't mean that we can just somewhere in the back of our mind believe that we've accelerated the note. What it means is that they don't have to provide any notice and opportunity to cure before they accelerate, but they do have to give notice that they've actually accelerated, and they didn't do that. So none of the documents offered in evidence contain any language where the plaintiff exercised its option. And also they conceded that no acceleration had occurred. So the final judgment should not have included the full accelerated balance, but only those amounts that had actually accrued as of the commencement of the case. And the trial court also should not have included default interest at the default interest rate, because if you look at the provisions of the default interest rate under the note, the default interest is only triggered if the note is accelerated. It's very clear. It says, it talks about the acceleration provision, the final principal, the full principal and all interest and fees become immediately due and payable, and default interest will accrue on that sum at the maximum legal rate. So it's only triggered if acceleration is triggered, and plaintiffs conceded that acceleration wasn't triggered. So the judgment should not have included interest at the default interest rate. In addition, the note is silent on the issue of the application of the payments to past due balances. And this gets into the back and forth between the emails that you saw Ms. Gibson send Hopheads and Mr. Ortiz regarding the monthly payments. You saw she would send in March, the March payment is due, pay the March payment. And then you would look at the payment history, and in fact, they made a payment in March. Then in April, you see the April payments due. And then you look at the payment history, and in fact, they made a payment in April. And so what you see is what is actually being said to defendants is, this is the payment that's due. This is the payment that's due. What's not being said is, by the way, we're holding this back we're going to apply it to past due payments. We're holding, and so you still actually owe the March payment because we applied what you sent in March to past due payments. They didn't say that. So there's the equitable principles are that you shouldn't accelerate based on a default when you've said make the payment and they make the payment that you told them to make. So there was no notice that payments would be applied to past due balances, and under these circumstances, it can only be assumed that the payments were applied to the current payments that were due. The defendants were lulled into believing that the payments were being received, that they were not considered in default, and so the plaintiff should have been stopped from claiming late fees and default interest on each payment based on its internal application of payments when it did not give the defendants any sufficient notice of payments. The defendants tendered payments, and for whatever reason, they were, well, not for whatever reason, because they apparently weren't by cashier's check, which was not required by any provision of the loan documents, they were refused. So equitable considerations prevented the enforcement of some undisclosed decision to accelerate or deem them in default. And finally, with respect to the subordination agreement for Tampa Hyde Park Cafe, the subordination agreement.
You're at your 5 minutes, but if you want to keep going, be my guest.
Okay, I'll wrap this up very quickly. The subordination agreement refers only to the mortgage of March 2014, while the leasehold subordination agreements refer to any and all mortgages. The two assignments of rent were updated and re-signed when the extended note and mortgage were signed, but the subordination agreement was not. The guarantees of Mr. Mustard and Mr. Ortiz were given as replacement for the subordination agreement upon the modification. Mr. Ortiz testified to that. And Mr. Ortiz testified that Tampa Hyde Park Cafe refused to subordinate the higher loan amount. So the evidence is that Tampa Hyde Park Cafe did not agree that its easement agreement was subordinated to the modified mortgage. It only agreed that it was subordinated to the original note and mortgage. And the case law is that intervening liens, even if they are subordinated to an original mortgage, they are not subordinate to later recorded mortgages. So the foreclosure judgment should only apply to the extent of the original mortgage, not the modified one. So the judgment was entered based on facts that had not occurred as of the commencement of the case. Plaintiff never exercised the option to accelerate the note. And so we request that the court reverse the judgment of the trial court. Thank you.
All right, that leaves you 3.5 for rebuttal.
Thank you.
Ms. Ahmed?
Yes, Your Honor. May it please the court, my name is Farha Ahmed and I represent Appellee Allstate Funding Corporation. Your Honor, I'd just like to sort of simplify the facts for you a little bit about what this case is about. The plaintiff, the appellee here, is a hard money lender, short-term private lender. This is a commercial loan and we're dealing with a property that's a parking lot. Here you have two sophisticated parties that have done business together on multiple occasions prior to this, and they entered into a commercial contract. On March 12, 2014, you have a note and mortgage executed, principal amount $129,500. Then same day, you have a subordination and easement termination agreement entered into between borrower and Tampa Hyde Park. There was an easement agreement, and then it said that the easement is subordinate to the mortgage and that entry of final judgment on the mortgage would terminate the easement. There was also lease subordination agreements, two lease subordination agreements entered that day, stated that those leasehold interests are subordinate to the mortgage and that entry of final judgment would terminate those leases. And then September 8, 2014, an extension and modification agreement was entered into, which
Can you go to the question or the argument that was raised by Mr. Grave about the acceleration issue where Mr. Kalu doesn't testify that the note wasn't accelerated and therefore this is outside the scope of the pleadings?
Okay, Your Honor, one, the court, if we could step back a little about, what the trial court decided and what the standard of review here is. Mr. Grave or appellant would have you believe that this is some sort of de novo standard here, but this is an abuse of discretion standard. And so what we're looking at here, we're not here to relitigate the facts and what the trial court determined. The trial court doesn't, or the appellate court here is not here to reweigh the evidence or the credibility of the witnesses. You don't look at whether there's possible contradictory evidence to, that supports arguments that were rejected below. We're not here to retry or substitute the judgment of the trial court on factual matters that are supported by competent substantial evidence. So given that, the court here decided that there were multiple defaults and multiple notices that were sent. At the very least, there was that August 12, 2017 payment, or there was a notice sent
The notice to cure.
on August 2nd, 2017 that said make payment by August 12, 2017, and they failed to make that payment. And so at the very least, there was that default. There was no, the trial court did not rely on the note maturing in making their final judgment. That is just a fact that the note matured on the eve of trial. And that was just simply a fact that was noted by appellee, and that was noted by the trial court, is that the note matured. And so there was no reliance on that. And so, the idea that the court relied on that, there's nothing in the findings of fact and conclusions
Well,
of law.
let me ask it this way. If there was no acceleration, then did the lender have the right to bring a foreclosure action?
Yes, of course, Your Honor. Any default of the note allows a lender to bring a foreclosure action.
And so does whether or not Mr. Kalu testified that they didn't accelerate the note is of no matter. That's what I'm trying to understand, what your position is on that.
Your Honor, Mr. Caillou isn't an attorney and doesn't even probably understand the legal, what the legal effect of acceleration is and what the meaning is. All he knew is that there was missed payments. And that's what he testified to, is that there were missed payments. Whether or not he knew the technical term of what an acceleration, what it means to accelerate or not, that his testimony cannot be taken to determine whether or not acceleration happened. The fact is that this is a commercial note of very basic terms, and this is, unlike a residential mortgage, a commercial note is, and this is very sort of bare bones note. Ms. DeGrave keeps talking about lack of notice. This note specifically says that no notice is required. There's no notice required to accelerate. There's no notice required to charge default interest. There's no notice required, there's no notice required to say, we're going to, no demand letters required actually in this note. It's, and so again, there's just no notice required. And so this idea that you can only accelerate if you provided notice, actually the note specifically says, and I'll read it to you, is sorry, one second, Your Honor, I'm trying to find the entire principal sum and accrued interest shall at the option of the holder become at once due and collectible without notice. And so it says that simply, without notice. And so it really is sort of by operation of law whether or not acceleration has taken place. The fact is that appellee had been charging default interest, and appellant had been paying default interest since February of 2016. I'm sorry, Your Honor. And actually, Your Honor, I'm a little surprised that now the argument seems to have changed a little at oral argument here, because the entire brief was focused on this lack of thoughtful and independent analysis of the trial court. And again, appellants argued that there was some de novo standard, and clearly, in Musgrave versus Musgrave, the Second District Court of Appeals stated that, when you're looking at whether thoughtful and independent analysis was done by a trial court, that's an abuse of discretion standard. And so the entire brief was framed around this idea that that thoughtful and independent analysis wasn't done by the trial court judge, because they used proposed findings of fact and conclusions of law. They used the appellee's proposed findings of fact and conclusions of law as a template. And so the argument, in a roundabout way, the appellant was trying to make this argument that, trying to get you to look at all of the findings of fact and make different conclusions, different findings by, looking at each one of these facts and saying, look, because they decided this way, they should have decided this way. And it shows that the judge didn't do independent and thoughtful analysis because, they decided this way on this fact, on the default issue, on the modification issue, on the estoppel waiver issue, when she should have decided this way. And therefore, the judge didn't do independent and thoughtful analysis. That was the entire argument made in the brief, and now all of a sudden there's no discussion of this.
Ms. Ahmed, can you walk me through how interest was because that we do have a finding from the trial court in the uniform foreclosure judgment. How did we get an 18% interest rate being charged?
That was, I believe, Your Honor, if I could get to it really quickly. And I can find the actual calculation for you, Your Honor.
Well, again, let me ask a better question.
Okay.
Start over. Where in the note will I find, or the mortgage, will I find an 18% rate charge? Because it seemed like 12.99, I think, was the ordinary
Right.
interest. So how do we get an 18% there? Where in the note gives
That
gives us
was that was the default interest rate, which says at the highest rate allowable under the laws of the state of Florida. And so at that point was 18%. And so
right. So point me to the provision in the note that ties that.
it says accrued interest shall bear interest from the time from such time until paid at the highest rate allowable under the laws of the state of Florida.
What are you looking at?
In the note, sorry, Your Honor, in the note, page 1173 of the record.
1170.
Yeah, and then the modified note is I
Same for
believe
the modified.
that was the original note, and the modified note, I believe, that was the original note, Your Honor. But again, the terms of the original note are, still remain, except for the modified terms.
Okay.
And again, as to that issue of the modification agreement, Your Honor, the terms are clear. It is a extension and modification of the original. It doesn't disappear. The terms of the original note do not disappear. They are only those specific terms in the modification are modified, and the rest of the terms in the original note remain. And that's why the subordination agreement and are still valid. The subordination agreements and the easement and leaseholds terminate upon the entry of final judgment. Your Honor, if you don't have any other questions for the foregoing reasons, Appellee Allstate Funding Corporation respectfully requests that this court affirm the trial court's order entering final judgment in favor of appellee.
All right. Mr. Grave, Ms. Grave, you've got 3.5 minutes.
I want to circle back to Judge Smith's question of Ms. Ahmed regarding the acceleration and whether if the note is not accelerated, the plaintiff still has the right to bring the foreclosure. And I want to make clear that we're not saying that the plaintiff doesn't have the right of foreclosure if there were missed payments. But the question is, what is the redemption amount? What is going to be the amount of the judgment that the borrower or that anyone with an inferior interest would have to redeem in order to prevent a judicial sale? And so at the time of the commencement of the case, the note hadn't been accelerated, the note hadn't matured, so the full principal of the note should not have been included in the judgment. We are not suggesting that they would not have the right to obtain a foreclosure judgment for the missed payments that they could prove, but we are saying that when you're looking at the redemption rights and what the amount of the final judgment should be, it should not include.
Can I ask you a question? Didn't your opponent say acceleration was automatic without notice?
Right. So the language says that if default of payment, then the entire principal and sum and accrued interest shall, at the option of the holder hereof, become at once due and collectible without notice.
So
That's
when
what it says.
they filed their complaint and asked for the entire principal. Was that an exercise of the option that they legally had?
Well, two things. So first of all, with respect to the question about whether it was automatic, it was not automatic because it's an optional clause. And Florida case law is clear that when there's an optional clause, it's not just an undisclosed, there has to be an exercise of the option and notice to the defendant.
So
And-
you're saying the complaint is not sufficient? Following a
Right.
complaint is not sufficient?
Well, a couple of things. First of all, Your Honor, is that when you look at the language, it doesn't declare that we are exercising our option here. It doesn't declare that. It says all it does is recite the language of the note, but it doesn't actually say we declare that it is accelerated. And then also the judge frequently throughout the trial said the complaint's not in evidence. The complaint's not in evidence. So what was in evidence at the trial was that the note had not been accelerated. And that's important because as I mentioned before, Mr. Meacham was preparing to question Mr. Calliew regarding the acceleration and regarding the fact that there were these emails that said, make the March payment. And then we made a payment in March, and make the April payment. And we paid it, and whether that would be, a waiver and estoppel. But then Mr. Calliew said, no, there was no acceleration. We're claiming the full amount because of
I don't want to interrupt you, but I do want to tell you, you've got 30 seconds left.
Okay. So I want to say that we're not suggesting that there's no right to bring the foreclosure. We're just saying that that it shouldn't be for the full balance. And then with respect to the issue of the thoughtful and independent analysis, when you look at some of the questioning of the judge, it's clear that it wasn't done, that what she just did was rubber stamp a uniform final judgment of foreclosure, didn't really consider the issue about the subordination agreement and whether it was still in place with respect to the extended mortgage, and didn't really consider those issues. She kept asking, why is this relevant?
You just ran out of time.
Thank you, Your Honor. We ask that the court reverse the judgments.
All right, I want to thank both sides. Thank you. We'll move on to the next case, which is the Spine Institute v. Moulton.